We are alive.
Good evening. Tonight's Committee of Adjustment hearing is being held by video conference and live stream video on the town's live stream webpage at oakville.ca. This is a hearing to consider applications for minor variance, and consents held under the authority of the Planning Act. Please keep in mind the intent of the process is to review the application that is before the committee, listen to the evidence, and then make a decision. This process is not intended to be used to resolve any concerns or disputes that may exist between the town, individuals, or organizations. If a request for a deferral is made and the committee grants such a request, the applicant, authorized agent, must contact the Secretary Treasurer to schedule a new hearing date. In order to conduct an effective and efficient electronic hearing, we have adopted the following process. If you are watching the live stream of this hearing on oakville.ca and you wish to speak to an item on the agenda, you can call 905-815-6095. Again, that's 905-815-6095. The phone number will also be posted on the screen below the live stream page at oakville.ca. Staff will be standing by to take your call, and when you do call in, staff will ask for your name and item number that you wish to address, and your telephone number. Then further instructions will be provided for you to call back to join the video conference. When the chair of the committee polls for interested parties, please press *6 to unmute yourself. The applicant agent will then be given an opportunity to explain to the committee the basis of their application and answer any questions that may arise. A maximum of 5 minutes will be provided for the presentation. You will need to state your full name and address for the record. Any submissions beyond the 5 minutes will be at the discretion of the committee. All delegations must also state their name and address for the record. A maximum of 5 minutes will be provided to make your presentation. All remarks and questions are to be directed to the chair. Any submissions beyond the 5 minutes will also be at the discretion of the committee. The applicant and agent will then be provided with a further 5 minutes to respond to comments made by interested parties, answer any questions that may arise from committee members, and if the applicant or agent has any concerns found in staff report, particularly with any proposed conditions, this will be your opportunity to advise us. The matter will then be taken into committee for a decision, and this will mark the end of all discussions. Any person desiring a notice of decision for an application must provide a written request, preferably through email, to the Secretary Treasurer. Written notice of the committee's decision will be mailed no later than 10 days for minor variance and 15 days for consent to the applicant, agent, and any other person who has filed a request for such notice. The last day to appeal the decision to the Ontario Land Tribunal will be noted on the decision. Only the applicant, specified persons, or public bodies may appeal the committee's decision to the Ontario Land Tribunal. In November of 2022, the Bill 23 legislation, which is the More Homes Built Faster Act, amended the Planning Act to remove appeal rights from members of the public. If no appeal is received within the prescribed timeframe, the decision of the committee becomes final and binding. The Secretary Treasurer will then notify the applicant and anyone who received a copy of the decision through written correspondence. People participating in the hearing are to be courteous to and respectful of the members of the committee, town staff, and other person participating in the electronic hearing. Tonight's electronic hearing is being video recorded and available for future viewing at oakville.ca. Thank you. We have one regret this evening. It's Mr. Michael Tolowski. Do I have any declarations of pecuniary interests? I see none. Thank you. Madam Secretary Treasurer, do we have any person requesting an appeal this evening? If you are in attendance and you wish to appeal your defer your application, please raise your hand and the Secretary Treasurer will invite you into the panel to speak. Again, this is a request for deferral or withdrawals of application.
Madam Chair, we do have Jason Hooter.
Go ahead, Mr. Heather.
Good evening, Madam Chair, members of the committee. Jason Heater on behalf of my clients at 26 Holyrood. That would be CAV 099-2024. Reluctantly, I will seek a deferral at this time to spend a little time with planning staff to work over a few adjustments to this application to see if we can bring everybody on side. And through email correspondence today with planning staff, they will, it's my understanding, they will waive the deferral fee as well. So.
Okay, very well. Members, all those in support of a deferral? Okay, the application has been deferred. You'll see the Secretary Treasurer at your earliest convenience.
Thank you very much.
Have a good evening. Anyone else, Madam Secretary Treasurer?
I don't see anybody else requesting deferral.
And we'll start with the first matter on our agenda, which is a consent application. I apologize. The first matter on our agenda is a consent application B23/09 at 3175 Lakeshore Road. Who is the agent for this application? I have Stefan Sherbach. I apologize if I'm pronouncing that wrong.
Good evening, Madam Chair. Actually, you pronounced it perfectly. Very good. Very well done.
Okay. Thank you for being kind.
Sorry, so am I first or is Mr. Toon first?
You are preparing the consent application, correct?
Yes, I'm the agent representing them. Yes, so I'm happy to do a quick presentation if you.
Yes, go ahead.
Okay, thank you. Madam Chair, members of the committee, my name is Stefan Sherbach. I'm with Planscape Inc., 104 Kimberley Avenue in Bracebridge, P1L 1C6. I'm here this evening representing the Cudmore family. I understand that they are watching the proceedings online. Many thanks to staff for their ongoing assistance, including their thorough staff report that includes a complete policy analysis and, more importantly, their positive recommendations in front of the committee this evening. As indicated in Mr. Toon's report, I think the application is fairly straightforward. It's simply an adjustment between common lot lines between the two subject properties. The purpose of the two requests, we're dealing with the severance now and the minor variances shortly after. The purpose is to create a vacant buildable lot with access from Victoria Street. The new lot, once the lot addition is consolidated, is in character with the typical lot size and frontages within the immediate neighborhood. There are no proposed changes occurring to the retained lot, with the exception of a minor reduction in lot area. As an example, the frontage along Lakeshore Road will remain the same as it exists today. As described in the staff report, the planning analysis is brief and accurate, and it follows our similar planning analysis that was submitted with the application. The submission included an arborist report, which provided a very clear inventory of trees, and a future owner of this lot will be required to follow the town's building permit process when they apply to build for whatever they decide to build. There are conditions that include securities to be paid to Oakville, and this is to ensure that the one main oak tree is protected throughout this future development process. In addition, with the submission is the heritage report that was submitted on the retained lot, and it has appropriate protection measures to ensure the heritage aspects are being maintained. This application was, I believe, brought forward to your council probably about a few weeks ago. So in summary, Madam Chair, I'm in full support of staff's recommendations as well as the noted conditions of consent. I would respectfully request the committee to support this direction. and I'm available for any questions you have with this file. Thank you.
Thank you, Mr. Sherbak. Are there any questions or items of clarification? Okay, I see none. Madam Secretary Treasurer, has anyone called in with interest for this application?
Not phone calls at this time.
Very well. We can take the matter into committee then if there are no questions and there is no interest from the public. Who would like to move a motion? Go ahead, Mr. Hardcastle. Thank you.
Excuse me. Thank you, Madam Chair. Having reviewed the materials, including the staff report, having heard the presentation from the applicant, and having reviewed the materials, in addition to having undertaken a site visit and reviewing applicable materials, I am satisfied that I'm satisfied with the consent application moving forward. Finding that it represents good planning and is in the public interest. Accordingly, I'll put forward a motion of approval. That motion of approval would be subject to the revised conditions of approval as contained within the staff report. So there are 8 conditions, revised conditions of approval, which is exclusive of what was previously provided as a number 5. I'm not going to read them out unless it's required for the record. So that's my motion. You're on mute, Madam Chair.
Thank you, Mr. Hardcastle. Madam Secretary Treasurer, would you like them read into record or you're okay with them as submitted?
I'm okay because it's stated in the report.
Okay, very well. So the motion is to approve the consent as applied for. All those in support? Okay, the application has been approved. Mr. Hardcastle, there is a variance application attached to this as well. Would you like to take that one as well?
Madam Chair, I'd be pleased to do so.
Thank you.
Having undertaken my site visit, having reviewed the materials, including the written staff report, and having heard the presentation of the agent for the owner, I'm satisfied that the requested variance conforms to the 4 tests of the Act. Accordingly, I'll put forward a motion of approval, subject to the 3 conditions noted in the staff report. Those being that the consent be 2309 be approved and the certificate of official issued. The approval will expire within 2 years of the date of the decision if the proposed scope of work has not been fully completed, and that the owner applicant enter into a minor variance and consent agreement inclusive of the subdivision of a tree security. The submission, I should say, submission of a tree security to be registered on title and to the satisfaction of the town of Oakville, reflecting a property information sketch dated November 3rd, 2023, prepared by Planscape, demonstrating a development envelope which protects tree 4 as outlined in the arborist report prepared by Jackson Arboriculture, Inc., dated June 2nd, 2023.
Thank you, Mr. Hardcastle. This is the CAV 107 of 2023, attributed to the address Victoria Street, Block 78. And the conditions have been read. Any discussion on these recommendations? Okay, I see none. All those in support? This application has been approved. Thank you, Mr. Sherbak.
Thank you, Madam Chair. Thank you, members of the committee. Good evening.
Have a good evening. Okay. We have application CAV 097 of 2024 at 444 Stanfield Drive. Again, that's CAV 097 of 2024 at 444 Stanfield Drive. And I have Ms. Stephanie Medviva as the agent listed.
Good evening, Madam Chair, members of the committee.
Good evening, Ms. Medviva, go ahead.
Thank you. For the public record, my name is Stephanie Metviva. I'm an associate with Glenschnar & Associates, the registered agent on behalf of the property owner. The address of Glenschnar & Associates is 10 Kingsbridge Garden Circle in Mississauga, Ontario. If I could have the next slide, please. The application before us tonight is for the property municipally known as 444 Stanfield Drive in town of Oakville. So the subject lands are on the west side of Stanfield Drive, located within an established neighborhood. The neighborhood itself contains a mixture of historic and newer built forms of varying size and architectural styles. So this means the neighborhood can be understood as having an eclectic and evolving neighborhood character. I'd like to have the next slide, please. And just very quickly, by way of context, this is a very limited photographic survey, but I did just want to highlight this is visual evidence to demonstrate the eclectic nature of the neighborhood. So the image on the top of the screen there illustrates the presence and the ability to have compatible development. So on the far left, there is an example of a historic built form, a detached bungalow to be precise. Alongside and complementary are newer built forms. And then just on the bottom part of the screen, again, there's the more historic bungalow built form on the far left that would be municipally known as 419 Stanfield Drive, alongside both a fairly modern architectural style built form and something that is a little bit more of an in-between architectural style. So again, just photographic survey to demonstrate there is diversity, there is an eclectic nature to the neighborhood. If I could have the next slide, please. And that brings us to the proposal before us today. So the owner is seeking permission to facilitate a replacement dwelling. It's a two-story, 306.86 square meter replacement dwelling. The proposed home has been strategically located on the lot. So as demonstrated on the site plan, the proposed home has been situated to provide consistent setbacks. It also maintains what can be understood as the prevailing pattern of front yard setbacks. So it is the front main wall is more or less in line with the existing main wall of the homes on either side of it. So generally, this allows the home to be situated in a general placement that's consistent with the existing dwelling. It serves to maintain the existing neighborhood character as well as the evolving neighborhood character. If I could have the next slide, please. So the proposal before us tonight triggers one variance, that being a request for an increased residential floor area. The request is for roughly 3.01% above and beyond what is permitted for residential floor area ratios. If I could have the next slide, please. Thank you. So the proposed dwelling has been planned and designed to better reflect the family's evolving needs. It's implemented a modern architectural design, which is again not dissimilar from that of an existing dwelling that's located on the east side of Stanfield Drive, just south of this property. So in order to maintain conformity with the Livable Oakville official plan, as well as the Livable by Design Urban Design Manual, the proposed dwelling itself includes architectural and urban design elements. So this includes a covered front porch, clear ground story elements, and an integrated roof line. When considered collectively, these architectural and urban design features avoid the appearance of a blank main front wall, which also serves to mitigate the adverse appearance of mass and scale of the proposed dwelling. It has an integrated front yard private garage, which again is a fairly consistent feature within the neighborhood, as is a covered front porch. And I'd also just like to highlight, as demonstrated in the side elevations, so those are the elevations on the top left and bottom left of the screen in front of us. the side elevations avoid general or an overabundance of openings and windows. This provides for a mitigation of privacy and overlook concerns. The proposed front and rear elevations similarly are sensitively designed to avoid the appearance of adverse mass and scale, but also to provide visual screening that's provided not only by rear and front yard amenity areas, but also by existing privacy screens along the shared property line. If I could have the next slide, please. This is a rendering prepared of the front elevation. So this just visually demonstrates those clear story elements, the front covered porch and the integrated roof line. So again, great care has been taken to make sure that this is a sensitively integrated development. It is modern architectural style, so there are limited examples within the neighborhood. I understand that it is not necessarily a complete deviation from what is existing, but it is consistent, it is compatible, and it does integrate with the evolving character of the neighborhood. I'd also just like to highlight that the surrounding neighbors were approached. If I could have the next slide, please. And this resulted in a signed letter of support, which I understand was included as part of the drawing package. So it is in the package before the committee. But this letter of support was signed by the immediate adjacent neighbor. So overall, as outlined in my submission letter, it's my opinion that the proposed dwelling and proposal before us is consistent and meets the 4 tests under the Planning Act. Happy to answer any questions that there may be.
Thank you, Ms. Medeva. Are there any questions for Ms. Medeva at this time? Or items of clarification? Okay, Madam Secretary Treasurer, has anyone called with interest to this application?
There is no phone calls at this time.
Very well, then we'll take the matter into committee. Who would like to move a motion? Go ahead, Mr. Hideki. You're muted.
Thank you, Madam Chair. Based upon my review of the owner's application, the site plan, building elevation, my site visit, together with the presentation by the owner's consultant and the planning staff's review, and having the support by the adjacent property owner, it is my opinion, or I'm satisfied that the variances are minor in nature and conform to the 4 tests under the Planning Act, and put forward a motion that the application is applied for be approved, subject to the condition that the dwelling be constructed in general accordance with the submitted site plan dated February 9th, 2024, and the elevation drawings dated December 7th, 2023, and that the approval expires 2 years from the date of the decision. Building permit is not being issued for the proposed construction.
Very well, thank you, Mr. Hideki. Is there discussion on this recommendation? I see none. All those in support? Okay, the application has been approved, none opposed.
Thank you very much. Have a good night.
Good night. Application CAV 098 of 2024 at 295 Morden Road. Again, it's CAV 098 of 2024 at 295 Morden Road. I have Nicholas Dell here as the agent.
Hello, community. Good evening. Can you hear me?
Yes, good evening, Mr. Dell. Go ahead.
Thank you, Madam Chair. Through you, Harper Dell and Associates is the planning consultant for the owner of this file. My name is Nicholas Dell. Our offices are at 1370 Hurontario Street in Mississauga. Subject application is an infill 2-story dwelling on a corner lot, and there are 4 variances we're seeking from you this evening, Madam Chair. 1 for a slight increase to the residential floor area, 1 for a slight garage projection, and 1 for the dormer height above the 3rd bedroom, which results in an overall peak building height. 9.20. There's also a flankage yard setback to the covered porch. And Madam Chair, I understand we have positive comments from staff, but if you like, I can go through a brief presentation to each of the variances and answer any questions you have afterwards.
Yes, go ahead.
Okay, thank you, Madam Chair. We're seeking a 2.9% increase to the residential floor area. The permitted amount is 41%. We're providing 43.90. That results in about 20 meters square. Generally speaking, I find lot coverage and building setbacks to be subordinate to RFA, but different sites and configurations and shapes of lots can somehow result in RFAs being exceeded based on the interior calculations of the zoning bylaw. The flankage yard, side yard setback relates to an uncovered porch. And so it's important to understand through you, Madam Chair, that it's not the main wall of the building that's encroaching into that flankage yard setback, but rather just an uncovered porch. So we felt in the abundance of caution, we would add that variance, which zoning agreed is appropriate. And the garage projection as well doesn't present itself as undue massing or too blocky from the street because it's actually adjacent to and almost flush, except for 18 centimeters with a covered porch. So when you're looking directly at the structure from the street, the intent of the garage protection provision in the bylaw, which is allowing 1.5 meters, whereas we're proposing 2.16 meters, is still well maintained by virtue of the covered porch. If you go to page 2 on the submitted presentation, oh, that's one too far. Go to drawing A2, please. That's what seems to be missing. My apologies to Jasmina, but quite sure there should be an A2 in the presentation. Biddy, I'm sorry, I'm not sure why it's not in there, but
Mr.
A2.
Dali, did you provide the presentation, or you're expecting to see all drawings from the submission?
The submission package is forming the basis
Okay.
of my presentation.
So the submission, we don't post the floor plans. Only elevation plans can go on the website. Since you didn't provide any presentation, only drawings that are on the website are available for tonight's presentation.
Thank you, Jasmine.
Mr. Dell, we have these drawings, so if you want to say something about them, we actually have them in front of us.
Okay.
For A2.
You. Yes. Okay. Sorry, Madam Chair. It's hard not to jump in at the wrong time virtually. I didn't mean to interrupt.
No, go ahead.
Okay, thank you. And thank you, Jasmina, through you, Madam Chair. I will make sure that we can provide additional presentation materials so that we can show them on the screen if need be, but I do appreciate the Chair's message that the committee has been provided these. Thank you. Visually speaking, Madam Chair, about A2, you will see, you will see on drawing, pardon me, please go to drawing A1. It's a first floor plan.
Okay.
And you'll see the covered porch matches pretty well flush with the garage. It's a covered porch, therefore the impact and the massing is I think, well represented and is not too impactful. So it does behave much like a compliant garage projection, but the covered porch technically isn't considered part of the main wall, so a variance is being sought for the roughly 2 feet that it projects in front of the main wall, but only about 18 centimeters in front of the covered porch. So that, Madam Chair, deals with the residential floor area variances and the garage projection. I'll now take you to the elevations, from the front elevations in page A3, which we have in our package. And you can see it's just the dormer above what's called bedroom 3 on the floor plans that exceeds to the peak of the roof. So it's a slight increase. It's not an overall height projection for the entire building, but just that peak is technically above the bylaw. It's an attractive feature for our client, and they are building their dream home. So we find it does mitigate an adverse impact, and it's minor in nature and I think desirable, given that it's not the entire massing, entire peak of the roof. It matches this one projection in excess of the minimum height. And lastly, I'll just conclude the 4 variances again. Is a minimum flankage yard to a covered porch on the side yard, to an uncovered porch, excuse me, on the side yard, a garage projection flush with a covered porch, a small dormer above the 3rd bedroom for a peak of roof height, and an overall of 2% RFA excessive residential floor area variance. And those are the 4 variances, Madam Chair. I'd be happy to answer any questions you have.
Very well. Thank you, Mr. Dell. Are there any questions or items of clarification of Mr. Dell at this time? Has anyone called with interest for this application, Madam Secretary Treasurer?
There is no phone calls at this time.
Okay. Thank you. Who would like to move a motion? Go ahead, Ms. Hugh.
Thank you. Based on my review of the application materials, together with the staff report, and having heard the presentation completed by the agent, in my mind, I believe the variances are minor in nature and conform to the for tests under Planning Act. As such, I like to move the motion forward to approve the minor variances subject to standard conditions. The dwelling be built in general accordance with the submitted site plan and the elevation drawings dated April 18, 2024. The approval expires 2 years from the date of the decision if a building permit has not been issued for the proposed construction.
Thank you, Ms. Hugh. Is there a discussion on this recommendation? I see none. All those in support? Okay, the application has been approved, none opposed.
Thank you, Madam Chair. Thank you, staff.
Good night.
Good night.
If you are watching the live stream of this hearing at oakville.ca and you wish to speak to an item of the agenda, please call 905-815-6095. Again, the number is 905-815-6095. Staff will be standing by to take your call and provide you with further instructions to join the video conference. Application CEV 100 of 2024 at 45 Pebble Ridge Place. Again, that's CEV 100 of 2024 at 45 Pebble Ridge Place. I have Pamir Rafi as the agent on record.
Hi, Madam Chair. Good evening, everybody.
Good evening. Good evening, Mr. Rafi. Go ahead.
Yeah, so I am the agent of the owner for 45 Pebble Ridge. My name is Pamir Rafiq. Our office is located at 1435 Cornwall Road in Oakville, and the company is Lucid Homes. So I want to just run through a couple of items here, keep it short. We have two variances for this home. One is a residential floor area, which is a slight increase by 3.8% in total. The second one is a height, 9 meters is allowed. We're going up to 9.3 meters. So it's a 0.3 meter increase. About the residential floor area, we have other variances in the neighborhood which are very similar to ours. Some that are higher, some that are lower. We're not asking for anything out of the norm. It's a standard 4-bedroom home, and we think that it's in keeping with the neighborhood. Planning staff is in favor of this, and they have given us written support of this as well in the staff comments. Regarding the height, we're asking for 9.3 meters. You can actually skip through the pages and go to the front elevation, if you don't mind doing that. So you'll see that a portion of the home is reaching the 9.3, whereas actually most of the house's height is actually below 9 meters. It's like 9.8, 8.8 and change. If you go to the next page, you'll see that most of the height, even here it's shown, and on the side elevations, that it's more than that is less than 9.9 meters for most of it. Regardless, we believe that we're in keeping with the character of the neighborhood. Homes of this caliber, with a roof that's shorter, it would kind of be disproportionate to the overall feel and look of the home. We find for architectural feature, a slight increase will do well aesthetically, and will upscale the neighborhood. And the small increase of 0.3 meters. We received support from the planning staff as well. So I'll leave it at that. I hope that everything is clear. If there's any further questions, I'm very happy to answer, and I hope that we'll get a positive feedback today.
Thank you, Mr. Rafiq. Are there any questions or items of clarification of Mr. Rafiq at this time? Mr. Dickey, go ahead, sir.
Thank you, Madam Chair. In your sketch, the site plan showing the proposed house and the statistics, you referred to gross floor area. Is the gross floor area for this house the same as the residential floor area?
Yes, yes, RFA. It's the numbers are the same. The numbers would be the same. It's just a matter of terminology. Yes, in Oakville it's called RFA. It's just a terminology, but it describes the same thing.
I've always been under the impression that the gross floor area included the total exterior measurements of each floor, but the residential floor area, you take out the area of the open to above. So in theory, I'm just pointing to them. In theory, your request for 32.8% RFA is actually higher because you could have subtracted from the way I understand it. I'm just pointing that out. I'm just going to leave it at that. That would be a concern of the zoning department, not me. And that's all. Thank you very much.
Okay.
Any other comments? Sorry, go ahead, Mr. Rafiq.
Oh, no worries. I would say if the verification of this, if you'd like it to be included as part of a condition, if you find that it's necessary, we're happy to have it included in there and make sure that it's done correctly. But from our side, I'm rather confident that it's done correctly. Same way that we always do with our Oakville projects. We follow the same guidelines and regulations for that.
Okay, thank you very much for that.
Thank you.
Anything further? Any other items of clarification or questions? Okay, I see none. We'll take the matter into committee. Who would like to move a motion? Go ahead, Mr. Hardcastle.
Thank you, Madam Chair. Having undertaken my site visit, having reviewed the materials, including the written staff report, having heard Mr. Rafiq's presentation, I'm satisfied that the requested variances conform to the 4 tests of the Act. I found that the staff report was compelling in reminding us of some of the decisions that we have made in respect to this area, as it's an evolving area that's under construction, and recognizing some of the what the character will appear to be when this isolated enclave gets to completion. Accordingly, I'll put forward a motion of approval, finding that the variances conform to the 4 tests of the Act. The motion should be subject to 2 conditions, those being that the detached dwelling be constructed in general accordance with the submitted site plan dated May 9th, 2024, and the submitted elevation drawings dated June 26, 2024. Elevation drawings for the June 26, 2024 committee agenda, and that the approval expires within 2 years of the date of the decision if a building permit's not been issued. I would note that there were no members of the public present with respect to this matter.
Very well. Thank you, Mr. Hardcastle. Is there discussion on this recommendation? I see none. All those in support? Okay, the application has been approved, none opposed. Thank you and have a good night.
Thank you. Enjoy the rest of your night.
CAV 101 of 2024 at 165 Gatwick Drive. Again, that's CAV 101 at 2024 at 165 Gatwick Drive. If you're interested in this application, please call 905-815-6095. Staff will be standing by to take your call and provide you with further instructions to join the video conference. I have Sam Ibrahim as the agent for this application.
Sam here.
Go ahead, Mr. Ibrahim.
I don't. This is Sam Ibrahim, Pan American Engineering. I am presenting my client for this minor variance application for this semi-detached dwelling unit located at 165 Network Drive. Like the property has a detached separate garage, and he wants to build a coach house on the top of it. But unfortunately, because of the depth of the lot, the current bylaw is not allowing the maximum height we are looking for. So we are asking for relief in this height. And also, like for the flank setback, there is like existing lighting pool that preventing enough parking stall for the car. So we are asking also for a relief for the extra parking stall required for this additional coach house on the top of the existing garage. Hopefully this meets your acceptance. Can you go to the next page, please?
If tech support can go back to the presentation, I don't think the applicant was done yet.
No. I just want to add some piece from it. It's not important. Just I want to show something. It's not essential, actually. So it's okay.
So the next
Not
page,
important.
please.
Yeah, like this is a proposed, but the problem is the existing lighting pool over there is holding it a little bit. They are asking for relief because the size of the stall is not fitting the bylaws.
Can we stream out of the, or
Yes,
would you
please.
like to show somewhere?
No. That's it. Thank you.
We have the drawings before us in any event. Are there any questions or items of clarification of Mr. Ibrahim?
Thank you.
Go ahead, Mr. Hardcastle.
Thank you, Madam Chair. I've got a couple of questions. The first question that I've got is of the agent is, has the next door neighbor been approached and provided, been shown the drawings and understand the implications of this? I understand that this is an attached garage to their garage structure. So do they understand the extent of the works and the implications upon their own structure?
Not to my best knowledge, just he was notified by the minor variance, but I don't think any structure discussions happen.
Okay. Perhaps I can pose a question of town staff. What, if any, requirements are there in a situation like this for an engagement with the property owner, whether it be through the planning processes or building permit processes, to ensure that they understand and their interests are protected?
Through you, Madam Chair, in regards to the minor variance application to begin with, there's the radius that the notices get sent out to. So the neighbor would have received notification about this particular committee of adjustment hearing. In regards to when a building permit's pulled, because it is a shared demising wall that their rear detached garage shares, it's something that we can speak to our legal team about in terms of what type of proper notification is required. I don't believe there's anything under the Planning Act that requires notice to be given in terms of construction, as long as any sort of damage or impact to their garages returned to a state of good repair as it was prior to construction. But those types of easements and those types of articles are all within the plan of subdivision, and when those were constructed 30 years, almost 25 years ago, I guess. But through you, Madam Chair, in regards to what has to be done in terms of notice once a building permit's applied for, I don't have that answer off the top of my head, but I can reach out to our legal staff if that's something that you wanted to pursue further.
And I asked the question, through Madam Chair, I asked the question because I did notice when I was doing my site visit that the abutting property is for sale, and well, I didn't go up on the front porch. It appeared that the building might actually be vacant. So I was a little bit concerned to understand the extent to which the existing property owners or future property owners might know. And you know, it's a challenging time to ensure that the interests of the abutting property owners are addressed. So I wanted to see if there was a procedural way that ensured that was addressed. So thank you, Mr. O'Hare. Madam,
I have a question. I'm going to piggyback off of you, Mr. Hardcastle. To my knowledge, with respect to, for example, semi-detached homes, even though they do share a dividing wall, the homes are still considered freehold, and each owner is allowed to do whatever construction that they will on their property. Does that principle apply to these garages?
Through you, Madam Chair, it would in this instance, yes. So as the rear lane detached garages are still part of the properties that contain, you know, the residential dwelling units, in this case, townhouse units, the same property for that would apply, yes.
Okay. But do they have a right to object to the second story on top?
Through you, Madam Chair, in this instance, because 365 Gatwick is a corner lot, in this area of the uptown core, you know, we have, there are provisions within the bylaw to accommodate additional accessory dwelling units above detached garages just on corner lots. So there's special provisions within the bylaw accounting for this along corner lots. An interior unit with a rear detached garage would have to apply for a variance to permit a additional accessory dwelling unit above that garage. So there is the permissions granted with having that additional dwelling unit. The zoning hasn't caught up in terms of height for that because the depth of the lot is less than 29 meters. So that limits all accessory structures, including an ADU, to 3.5 meters in height. So through the uptown core, you know, built form and development, it's been contemplated to have these additional accessory dwelling units built on corner lots where these rear detached garages are. With that said, though, in terms of notice again for the neighbor, because they are freehold units and they're are shared condominium road in terms of access, but for waste collection, the unit itself for freehold, there is no, as my understanding, and again, you know, through you, Madam Chair, can touch base with our legal department in terms of notification for construction on their own property. Again, with that said, if there was any damage done to their portion of the garage, it would have to be rectified, or else that owner has a legal means of ensuring it gets fixed. If there's any damage done to their property, it wouldn't be dealt with through the Planning Act, but through small claims court, et cetera, that they could get any sort of, you know, remittance on that.
Okay, thank you. That answers my questions. Mr. Hardcastle, do you have any further follow-ups?
I did not have a follow-up on that. Thank you for the additional questioning. It's assisted me to some degree, but I did have an additional question that I hadn't got to yet, if you don't mind, Madam Chair.
No, go ahead, sir.
I had noted, I'd actually gone by the site more than one time because I had noted that I'm looking right now at the picture of the existing garage that was part of the staff report, and there is the park, the space immediately adjacent to the garage. that is encumbered by a pole that's affecting the ability to provide the required additional parking space for an ADU. And I note that the same vehicle was parked there on 3 separate occasions in that spot hanging over the sidewalk. I'm not sure what I don't. I mean, I'm not particularly concerned about providing an ADU and allowing market conditions to address the marketability, if you will, of that ADU. But where there's an existing condition already that the owners or visitors of the owner seem to be utilizing this space and compromising the people's ability to pass by on the sidewalk. I am a little bit concerned about that and what the decision will do in terms of exacerbating that condition, whether it's an irregular. I just was by on a couple of occasions, that we're irregular, or that this is going to be an ongoing thing. Is there a remedy, and this is to the town staff, is there a remedy that we can put in place here that would ensure or protect against this kind of thing going on? Because this space really is not large enough for a full-size vehicle to fit in.
Yes, through you, Madam Chair, for instances like this, where a car encroaches upon the public right of way or is overhanging the sidewalk, the best course of action in this case would be to involve municipal enforcement services, to get a bylaw enforcement officer out on the property and issue a ticket because a vehicle is not allowed to encroach or be placed within a sidewalk. Also involve Oakville traffic services as well. That being said, that's on a case-by-case basis and doesn't ensure that the space is always unencumbered and that there are no vehicles parked there. If the applicant was amenable, we might be able to include a condition stating, in addition to the 2 other ones that have been put forward, that something to the effect, and committee can change this wording perhaps if they want to, but a full-sized vehicle shall not be placed within any portion of the public right of way. Again, enforcing this particular condition, because there is room to put a motorcycle, but any sort of commercial vehicle or regular vehicle, a car, a sedan, you're right, there is not enough room. So again, an enforcement of this condition, it would be there'd be legal ramifications with it, as instead of on an enforcement basis, it would be tied to the approval of the ADU, ensuring that there are no vehicles placed within this particular area, noting that a vehicle is not allowed to encroach or be placed upon a public sidewalk. So if Mr. Ibrahim is amenable to perhaps including some sort of condition in the approval, having it in writing, I'll leave it up to your hands.
I mean, there is a sign that says no parking on that pole. So
there is, yes,
it's really,
Madam Chair. And again, this is something that can be on a complaint basis be addressed through a traffic and municipal enforcement services, to issue tickets and orders to comply. That's usually kind of the remedy that's done in most cases. Because again, it's unusual to have a condition like that placed within an approval for an ADU. I know this case.
But I also, sorry to interrupt you, but I also get what Mr. Hardcastle is going at.
Mm-hmm.
They may not need it now, even though he has seen a car there on several occasions. But certainly once that coach house goes in, and if it is going to be a rental property, they will need another spot, I'm assuming.
Madam Chair, and that's one of the things that we spoke, or that was mentioned in the staff report, is when this unit is advertised, whether it's through MLS or whatever means, that it needs to be made clear within the rental agreement, if it's, you know, to be rented out through someone that's not, you know, perhaps a member of the family or whatnot, that it does not come with a parking space. And so that's something that, you know, again, isn't really organized through us or dealt with through us at, you know, committee, but is something that the applicant should be aware of, that there will be ramifications if a potential renter does in fact think they're able to park a car there, because they're not, and there are laws in place to prevent that from happening.
Okay. I'm okay with a condition if you so deem. Mr. Hardcastle, if you move the motion, we can put it in. How enforceable it is, we don't know, but it doesn't hurt to put there. If Mr. O'Hara says it's okay with them, then I'm okay with that as well. Mr. Dickey, go ahead.
Thank you, Madam Chair. I'm a little bit confused about this. In the sketch, it says the light pole is to be relocated. So it's not the light pole that is the problem in using this space that is actually on the property. The problem is that the space is too narrow or not long enough. I guess I should say, asking the owner's consultant this question, maybe the planner afterward. Is the pole being relocated? The first question.
No, the pole was not relocated, and yes, to my best knowledge, the car squeezed there a couple of times. I have seen it, but the size of the existing space for the car when it goes to the maximum middle of the span, it is still not as per the planning requirements for the minimum car store. However, I think we submitted a letter that states that the owner is not looking to rent this unit, is doing this for his in-laws, and we wrote for his personal use, not as accessory unit. So like you.
What is the width? I assume it's the width of the space that is insufficient. From what I can see, the width
0.3 meter.
Sorry, say again.
If at the very middle of it, if you move to the house, it is 2.4 meters.
And the question is, what is the minimum width of the zoning bylaw? The zoning
2.7.
2.7.
2.7.
2.7 or 2.4. 2.4. So you're short there. And Mr. Hardcastle has been there and seen hard cars parked there, and it's definitely insufficient width.
Madam Chair, if I may just sort of
Yes.
clarify my position for what I observed for Mr. Dickey. Do you mind?
No, go ahead.
Okay, because of the location of the light standard, a vehicle could not enter straight in. Well, a vehicle could probably fit closest to the fence because it is a trapezoidal shape, so narrower as it's in front of the light standard, but wider in front of the gate. The vehicle was on an angle such that the rear quarter panel of the vehicle was hanging over onto the sidewalk. And, you know, unless a vehicle were jockeying back and forth, would be unlikely to be able to fit in the space provided unless it was a small vehicle, or as Mr. O'Hara spoke to, a motorcycle or something like that.
I also note that the property right across, they have a similar situation where they have a coach home on top of the garage, and there is a staircase. Mr. Ibrahim, from your drawings, it's going to be similar to this, where you have a staircase coming down the side, correct?
Yes, but I want to add one small point. If you go to the other side plan, the proposed one, we shifted the fence to add more width to the trapezoidal part.
Oh, okay.
Yes, you are right, sir. as per the current condition, where the fence is now, it is very tight, but if you shift the fence little bit to the south, it gives you more trapezoidal space.
Can I ask a question again? I'm a little bit confused.
Go ahead, Mr. Dickey.
Why can't you move, if you were to relocate that light, that pole, would that make that potential parking space usable, excepting for the fact it's too shallow?
It will,
I
assuming
don't think they can.
you get a relief on the parking stall to be 2.4 meters.
I agree. And I'd rather give you a variance for that, for the width of the parking space, than give you a variance for not having a parking space.
Agreed.
That's what I'm thinking, to be honest.
Agreed.
Oh,
Mr. O'Hare, the applicant doesn't have the right to move the light. That's a municipal or a property,
Yes.
isn't it?
Yes, through you, Madam Chair. There are requests that are done for relocating utility poles, which are done through Oakville Hydro and through the town for a light standard. It's a different process. It's usually not something that's permitted.
Okay, so I don't think that this is something that we should discuss any further then. I think we should move on. We have, I think, all the questions that we've had in our minds answered. If there's no one who's waiting to speak to this application, Madam Secretary Treasurer,
No,
we
but
can take the matter in.
I see Miss Lindsay, you want hands up?
Oh,
So she wants
sorry,
to
Miss
speak.
you. I always miss your hand.
No,
I apologize.
No
Go ahead,
problem.
Miss you.
Yeah, I was just going to point out, I don't know if that lighting pole is actually belongs to the Oakville Hydro. It looks like this is a laneway. I don't know if the lighting pole belongs to a Oakville Hydro or the condo board, well, the laneway board. That's different story. And also, I don't know if the residents on the corner lot will have that issue, because it looks like this is the sidewalk along the main street. In the winter time, there will be snow removal, and I think likely the snow will be stockpiled in that area. So I do have some concerns about the parking over there on both corner lots. The other side, which one also has a unit on top of the garage. So I think maybe the owner can advise if you guys have this issue during the winter time when parking the car, because in summer you can squeeze your car in through the sidewalk in and out and move around a little bit, but in the winter time, how did you get in and out?
No, I don't think that this is it's a legal situation. I think what Mr. Hardcastle witnessed was someone squeezing in there on their own accord, but the applicant is not seeking to have a parking spot. They're asking for a variance for relief from having a parking spot attached to the new accessory dwelling that they're going to be putting in. We were just debating whether the situation can continue the way Mr. Hardcastle witnessed, and whether we should actually put in a condition to mitigate that, to avoid that situation happening over and over again.
Yeah.
So
the reason I pointed out is that so if they already have difficulties to park a car on the existing spot over there, so and also they are proposing amendments to not to require a parking spot for additional unit on top of the garage, so that concerns me, because maybe they will lose, like they won't be able to have enough parking lot. Where are they going to park the cars? Especially likely, I mean, potentially the unit on top of the garage will be rented out or will be occupied by visitors or family members. Of course, the extra parking will be required. So if they lose too much parking areas, how that be satisfied? I don't want to see like a parking issues raising in that area after we approve this variance. If there's a condition that can mitigate this issue and can be enforced in future, I would feel more comfortable to approve this minor variance.
Mr. Ibrahim, do you have anything further to add? You did mention that this is for their personal use, for their in-laws, so they are not expecting to need an additional parking spot. You're muted. You have to unmute yourself.
Yes, they are not expecting to rent this unit. They are expecting their in-laws to come in the summertime. However, I am so happy with the idea of having a relief on the parking stall size, because when we shift the fence, we're gonna end up having like 2.4 meters to the property line, which will make our life easier. And this will leave us with two issues: how to maneuver going behind the pool, which is not nice, but it's happening. Thank you. And still there is a potential to move the pool if we find a way to move it. And the client is okay to move the pool.
In that case, it would be a completely different application. But that's not what we're entertaining right now.
I would stay with my application. I would stay with that.
Go ahead, Mr. Hardcastle.
Thank you, Madam Chair. I have this line of conversation. Maybe we're going too far down the path here, but this line of conversation has raised a question in my mind, and that is whether the town of Oakville utilizes what is referred to as a 0.3 meter reserve block adjacent to properties, particularly on end blocks, to restrict and control access in places where the town is not looking to have driveway accesses. I know my employer utilizes them for that purpose, and I was curious whether we're starting to pick at something here that may not be practically able to be done between the pole and tools like a 0.3 meter reserve. You'd be putting them into a legal challenge or issue here.
Mr. O'Hare, I think that was yours to take.
Yes.
Sorry, I didn't expressly say that.
No. That's it. Madam Chair, so for the 0.3 meter reserve, it's usually done between at the intersection of two public roadways. So it's usually not for a private laneway and a public road. It's usually between two public roadways at the intersection. In this particular case, thinking back to including a condition to prevent any parking within this area. The one thing I just have a problem with is the enforcement of that, because that's usually the conditions are, general accordance with the plan submitted, and that if a building permit isn't pulled in 2 years, that the decision expires. But in terms of enforcing an owner or resident or renter, to prohibit a vehicle from being parked in that place, it's going to be hard to implement, both from a legal standpoint and from an enforcement standpoint. So just thinking back to that that condition to be included, I actually don't think that we're able to include such a condition as that for this particular application. So it would be heard on the merits of the two standard conditions, knowing that within our staff report and getting, again, direction from the province and from, federal government, from the town about the need that we're in a housing crisis and we need additional dwelling units to help support, the additional population coming to the town. That in this particular case, it would be, the onus would be on the owner to find a tenant or to, lease to a child or to a family member that didn't own a vehicle. And if they were to own a vehicle and decide to park there, there are means within the town through enforcement to ensure that that car is moved and is not allowed to be parked there. So there are mechanisms within the town's bylaw, in addition to, other enforcement tools that there are outside of the planning realm to help address that. So looking at this through a planning lens was, it's in the uptown core. The whole purpose behind this neighborhood was to have a dense, compact neighborhood that's transit friendly, transit accessible. There is on-street parking for visitors on Gatwick. It wouldn't be for the renter or the owner, as you're not allowed full-time permanent parking on this road. There's the bus loop that's right at Dundas and Trafalgar at Walmart, which is within a 5 to 10 minute walk, which goes straight to the GO train station. So we looked at all of these different things when preparing the staff report, saying, we're trying to meet the goals of what the uptown core is supposed to be, which is a walkable, transit supportive, dense urban neighborhood, and to get people away from reliance on vehicles and personal vehicle use. That being said, the person renting this place or the family member who's going to be living above the garage has to know that a parking space has not been provided for, and that's what the purpose of the variance application is tonight, and that there are consequences and ramifications for parking a vehicle there, which include enforcement and other means. So I just want to let the committee know that it wouldn't be appropriate to add a condition, and that based on the evidence provided and the location of this particular additional dwelling unit in the uptown core is the reason behind the positive staff report for not providing a single parking space.
Very well. Okay, we have it. Mr. Dickey, go ahead.
Hopefully I'll be short. Looking at the legal description of this property, is not a condominium. It's either, I thought it was a semi-detached house, but the town planner thought it was a townhouse. Doesn't really matter. It's not a condominium. The question is, who owns that laneway? Either the town or it's a common element condominium. My thought is, if the town owns it, it would a better solution to the problem, from my point of view, is the town allow the owner to move that pole and therefore make access to that, what was always anticipated in my mind to be a parking space, because that's what happened at all the other corner lots in that subdivision that I quickly observed. Allow that to be used as the parking space. The owner goes and asks for a deferral and comes back asking the variance to be reduction of the dimensions of the parking space so that we can use it. If I can understand properly from what Mr. Hardcastle said, the car is overlapping on the sidewalk, possibly because you can't get into it in a decent manner because of that hydrophone. Well, that would be the way that I would think I would, I would not support a condition saying that that space cannot be used for parking. I think it should be used for parking, and we should bend over backwards to see if that is feasible and possible. Thank you.
Through you, Madam Chair. Double checking the survey and our property records just on our town website while Member Dickey was speaking. I did double check and confirm that the laneway is town owned. So it is not part of a common element condominium. So with that being said, there still is no guarantee that our roads and works operations would be amenable to relocating that particular light standard to allow for a usable parking space that would have a reduced width. So we could, go through this process and ask for the applicant to defer, but there's no guarantee that the town would in fact be okay with relocating that light standard, and that we'd be back in the same situation with the same variances.
Yeah, I agree with you, Mr. O'Hare. Here's a summary of where we stand. Mr. Ibrahim, we have to rule on the variance as requested in this application. It is your choice if you want to pull your application, pay the deferral fee, and try and apply to see if it is possible to get a parking spot allocated in that area. There is no guarantee, as you just heard. or we proceed as planned, and we make a ruling based on the variances that are requested, and this conversation is on record. Municipal authorities can tag and ticket any non-compliant vehicle, as it is a municipal laneway, and there is a no parking sign there. So how would you like to proceed?
Madam Chair, can I
Yes.
interrupt you for a second?
Sure.
If you can repeat the number, I do have an owner who wants to join the meeting. However, I have a difficulty. If you can repeat the number and wait a couple minutes until we see that he joined the meeting, would be great.
Okay, repeat which number? The application that we're on right now?
No, the number that he can call in regards to.
Sure.
Yes, please.
It's 905-815-6095. Again, it's 905-815-6095.
Thank you.
This is a person with interest to this application, Madam Secretary Treasurer?
Correct.
Okay.
And
they waited quite a long time to join in.
Yeah, and if you can wait a couple of minutes.
Mr. Dickey, yes, sir.
Just while we're waiting, I just asked a question. I don't know if it was you who said that at the spot, there's a no parking sign right at the spot or on the road?
Yes. No, there's a no parking spot on the pole that is impeding a car to proceed directly into that area.
But isn't those no parking signs relating to no parking on that side of the Blanket Street?
It's in planning's staff's report. Just look at the pictures. It's on the the second, see the pole? And then in the second picture, if you zoom in, you'll see it. It's a no parking. It says it right there. So, I mean, I'm assuming that the municipal parking authority is the one that put these signs up. Whether people respect them or not, we can't enforce that. They do. Go ahead, Mr. Ibrahim. You have your hand up.
Thank you. Thank you. I think I will proceed. Just small clarification. If you look at the drawing, it will show that if we shift it, yes, as per the current location of the fence now, and the trapezoidal shape, it cannot reach a point where it's wide enough. If we shifted the fence as per the proposal, we will have 2.4 of a meter because of the trapezoidal shape.
In that case, you'll have to file an application to be able to get.
No, I will proceed with this and just thank you.
Okay. Madam Secretary Treasurer, have they joined?
I'm expecting any second that he's going to join.
Okay.
Thank you.
Through you, Madam Chair, if you don't mind, just wanted to add one more thing just for the committee's benefit.
Sure, go ahead, Mr. Hay.
Thank you. Just for the committee's benefit, this particular address, 165 Gatwick, again, it's located in Uptown Core, just south of Dundas Street near Trafalgar Road. North of Dundas Street, there's a different zoning bylaw that's applicable to all lands north of Dundas. So it's 2014-014 south of Dundas, and then 2009-186 north of Dundas. In the 2009 bylaw, recognizing that additional dwelling units, are at that point becoming more common, there are in fact no parking requirements for additional ADUs north of Dundas Street, just for the community's benefit. So an ADU does not require to have a parking space. So as of right, within the town, you can have 3 units per each property. And you have the main residential dwelling unit, which is required to have parking. The 2 additional dwelling units north of Dundas are not required to have parking. So there are areas within the town where this sort of precedent exists for having ADUs added onto a property without having any required parking.
Very well, that makes sense, and it's not far off from this location of the property.
Thank you.
Madam Chair, Yaha Moyena joined the meeting, right? And you can call him.
Hello.
Good evening, Mr. Moyena, right?
Yes, nice meeting you, everyone. I'm Chairman and Committee of Adjustment. I just wanted to clear a few questions. I was following the live stream. There was a question. I'm the owner of the property along with my wife. And I just following up on a few questions. There was a question regarding the parking, no parking sign. This no parking sign is not for the parking pad within my property. It is for the laneway, the sides of the laneway, because some people, they park their car parallel to the garage doors. And this is what's not allowed, not parking in that particular spot. So just to clear that. And then, but just building on what Mr. Ibrahim said, the car now, as I park it, it's around 2 to 3 centimeters protruding to the sidewalk. I was not aware that this was a problem, as the person before me, like when I bought the house, was doing the same. But knowing that this is a problem, hearing the other members, respective members of the Committee of Adjustment, I can make sure that this does not happen again. It's just harder to park that way, but I could park between the light pole and the garage wall, and I did it several times. It's just harder. That's why I do it diagonally as it is. But even if I do it diagonally, it goes just 3 to 5 centimeters. Just pushing the fence by a few centimeters would alleviate this problem. And even if not, I have 3 vehicles. One of them is motorcycle and cars. I have the motorcycle in the garage for fear of theft, but I can switch the car with the motorcycle and have the motorcycle parked outside, and this wouldn't be an issue.
Okay. Thank you for that clarification. Are there any questions or of Mr. Moreno? Okay. I think we'll take the matter into committee and we'll move a motion based on the application and the variances before us for the accessory dwelling units without a parking and the height of the accessory building. Who would like to move a motion? Oh, go ahead, Mr. Hardcastle. Thank you.
Thank you, Madam Chair. Interesting conversation here tonight. Covered lots of ground that is, I think, as Mr. O'Hara has pointed out, we perhaps strayed a little bit away from what we really should have been talking about to some degree. But I think it's important for us to understand these pieces as we're seeing more ADUs coming in, and we really need to wrap our heads around the appropriate criteria and things to be considering in these facts. I know myself, I struggle a little bit with these some ADUs in some areas where there's where there may be limited practical options for somebody who has a vehicle, and they may not have a lease commitment for a parking space, but they have a vehicle and they need some place to put it, kind of thing. It encourages that kind of thing. But Mr. O'Hara has been ever so helpful in reminding us that enforcement is there for a reason. And whether it be for my neighbor that has 4 cars and 3 parking spaces, and geez, I hope he's not listening tonight. It be a situation like we're talking about here. The reality is enforcement is there for a reason. There are key areas within the city that are called for intensification, and what I think the planners would refer to as gentle intensification, like we're seeing here. This is the kind of thing that helps us achieve the housing objectives that have been laid out rather aggressively by the province, and fulfill the town's obligation to achieve those housing targets. This site is located in an area that's called for this kind of thing, has the amenities to facilitate and accommodate for additional dwelling units. It has, with higher order transit, better walkability than you have in other places of the town. This is one of those key areas. With that being said, I find no objection to the actual variances that we are seeing here, and accordingly, I will put forward a motion of approval for the variances as requested, finding that there will be little to no impact upon abutting property owners that cannot be remedied by available mechanisms, whether they be building permit in terms of my first line of questioning, or whether they be enforcement in terms of the bulk of our conversation. I do find that the variances conform to the 4 tests of the Act. The motion will be put forward subject to the 2 conditions contained within the staff report, those being that the dwelling be built in general accordance with the submitted site plan and elevation drawings dated February 27, 2024, and the approval will expire within 2 years of the date of the decision if a permit has not been issued. Thank you, Madam Chair.
Thank you, Mr. Hardcastle. Is there discussion on this recommendation? Mr. Dickey.
I would agree with this. I don't usually like the idea of giving an exemption for the third parking spot if there's a possibility of accommodating it on the site. I would prefer that the owner possibly move that fence a bit and use that property. But I leave it up to him and his dealing with his future tenant or whatever. So I would vote in favor of allowing the exemption.
Okay. Thank you, Mr. Dickey. Any further discussions? I see none. All those in support? Okay, the application has been approved, none opposed. Thank you, and we appreciate your patience.
Thank you so much. Thank you.
Have a good evening.
Thank you.
Okay. 905-815-6095 is the phone number if you're interested in an application and you would like to call. Staff will be standing by to take your call and provide you with further instructions to join the video conferencing. The next item on our agenda is CAV 050 of 2024, deferred from March the 20th of 2024. And this is at 2441 Hickson Street. Again, this is application CAV 050 of 2024 at 2441 Hickson Street. Good evening, Ms. Yan. Go ahead.
Good evening. My name is Luis. I'm representing file number CAV A050 2024, which at 2441 Hickson Street. So previously, we requested a deferral because of the staff's comments. So what we've done since then was we coordinated with the planner and totally eliminated the height variance. So we are now only seeking for 1 variance for the residential floor area to increase about 4.62%. So we made some massing corrections to the facade of the building. On the left top corner of the page, you can see the original front elevation. So we changed the material and color of the exterior veneer on the 2nd floor. Above the garage on the 2nd floor, you can see there was a gable roof, which was changed to a hip roof. to lower the roof line. Also, on the rear elevation, we cancel the open to below area above the family room. So the area becomes to 1-story height only. So if you see the site plan, it's on the west north corner of the building, and it's facing to the rear yard and the side yard to the neighbor's driveway. So these are the revisions we made to mitigate the mass and scale. Next page, please. Sorry, next page, please. So on the staff report, the variance of the residential floor area we requested is 45.22%, which is different with the actual number, 45.62%. So I want to make a clarification on this. So there are 2 exterior walls around the family room on the first floor. One of them is facing to the west side, another one is facing to the north side. So these 2 walls, they are actually 1 meter above the second floor. So on the second floor plan, it's on the left top corner of the page. You can see these 2 exterior walls area is 2.7 square meter, which was added to the total residential floor area. That's how we got 45.62%. And if you look at the second floor plan, this area is not an open to below area, and there's no access to the second floor. So I understand we have the planning staff support, and we do feel that our application requests the character of the neighborhood and satisfy the floor test. So I'm happy to answer any questions. Thank you.
Thank you, Ms. Yang. Are there any questions or items of clarification? Any questions? Okay, very well. If no one is called into this application, Madam Secretary Treasurer will take the matter into committee.
There are not phone calls at this time.
Very well. Who would like to move a motion? Go ahead, Ms. Yu.
Thank you, Madam Chair. I appreciate that the applicant has made the effort to reduce the number of the variances for this proposal, and I do see their effort. And based on my review of this application materials and the revised drawings, as well as the presentation done by the applicant, in my understanding, this proposal minor in nature, then the meet the 4 tests under the Planning Act. Accordingly, I'd like to move a motion forward to approve the application subject to conditions. The dwelling be constructed in general accordance with the submitted site plan and the elevation drawings dated May 26, 2024. The approval expires 2 years from the date of the decision if a building permit has not been issued for the proposed construction. Thank you, Madam Chair.
Thank you, Ms. Yu. Is there a discussion on this recommendation? See none. All those in favor? Okay, your application has been approved, none opposed.
Thank you, Madam Chair. Have a good night.
Have a good evening. Okay. Application CAV 068 deferred from May 1st of 2024 at 499 Rebecca Street. Again, that's CAV 068 of 2024 at 499 Rebecca Street.
Good evening,
Good
Madam
evening.
Chair and committee members. My name is Manjinder Kaur and I'm the agent representing 499 Rebecca Street. Our proposal is to construct a two-story single detached house, and we have requested two variances on May 1st, 2024. The maximum residential floor area ratio, the required floor area ratio was 41%, and on May 1st, 2024, we requested for 48.41. Now we have reduced it to 45.42, and the other variance is maximum lot coverage, which the required is 25%. On May 1st, we requested 29.26%, and we have reduced it to 28.58%. As seen in our revision, we have discussed our proposal with the town planner, and the staff has now given us the positive feedback. If you can see, can you go to the next page, please? Next, the proposed elevations. So this is the new proposed elevation in which we have made changes. So the revision have been made to reduce the massing of the proposed dwelling to provide an adequate transition to the existing dwellings in the immediate neighborhood. The floor area ratio and lot coverage variances have been reduced to mitigate some of the massing and scale concerns from the original proposal. This also results in slightly smaller building footprint, therefore decreasing the amount of hardscape. Additionally, the two-story front porch element that projected outward towards the street has been lowered to 1 story in height to reduce the impact on the public realm. The height of the dwelling has also been lowered from 9.78 meter to the maximum allowed, which helps to further reduce the concern over any potential shadowing or overlook conditions onto abutting properties. The introduction of 1-story front porch element, along with the inclusion of a decorative wooden railing along the westerly portion of the dwelling, helps to create a continuous architectural element along the front facade between the first and the second floor. This further assists in breaking up the verticality of the front facade by de-emphasizing the height and massing of the dwelling. As per the discussion with planning staff, the reduction to the floor area ratio and lot coverage variances, in addition to the changes made to the front facade, help break up the massing and scale of the dwelling and adequately mitigate potential impacts. And we have requested now for maximum residential floor area ratio to be 45.42% and maximum lot coverage to be 28.58%. If you have any further questions, I'll be happy to answer those.
Thank you, Ms. Kaur. Any questions or items of clarification? Okay, I see none. Who would like to move a motion? Go ahead, Mr. Dickey.
Thank you, Madam Chair. Based on my review of the owner's application, site plan, building elevation, my site visit, presentation by the owner's consultant, and the planning staff report, I am satisfied that the variances are minor in nature and conform to the 4 tests under the Planning Act. I put forward a motion that the application as applied for be approved, subject to the condition that the dwelling be constructed in general accordance with the submitted site plan and elevation drawings dated May 17th, 2024, and that the approval expires 2 years from the date the decision the building permit has not been issued for the proposed construction.
Very well, thank you, Mr. Dickey. Is there a discussion on this recommendation? Seeing none, all those in support? Okay, all those opposed? Okay. Your application has been approved with 1 opposed.
Thank you, Madam Chair and committee members.
We have minutes to confirm for June the 12th. Mr. Hardcastle, thank you. And then motion to adjourn. Mr. Hardcastle, thank you. We are adjourned at 8:40 p.m. Madam Secretary Treasurer, please let us know when we're offline.